seated. All right, Mr. Hubbard.
Yes, sir, Your Honor. We're here today on State versus Mary Rebecca Hill. I've got the indictments and Senate sheets prepared for Your Honor, along with a waiver from Richland County and a waiver also from Colleton County. There's 4 separate charges. 3 of them come out of Colleton County. There's 2 misconducts, misconduct in office. Those be indictments 2025 GS 15, 289, and 290. For the record, Your Honor, those were indicted under the common law, but we've agreed to proceed on the statute. They're both misdemeanors. And so technically, those would be waivers. And then the obstruction of justice, that's also out of Colleton County. That's a 10-year misdemeanor. And then the perjury out of Richland County, that's a 5-year felony. Other than what I've just mentioned, there's been no other deals. There's no recommendations, no negotiations as to sentence.
Okay. All right, Mr. Clerk, will you please swear in Ms. Hill?
Raise your right hand. Place your left hand on the Bible. State your name, please.
Mary Rebecca Hill.
Do you solemnly swear or affirm to tell the truth in the court today? So help you God.
I do.
State your full name. Spell your last, please.
Mary Rebecca Hill, Hill.
All right, Mr. Lewis, have you explained the nature and elements of the charges, potential punishment, as well as Ms. Hill's constitutional rights?
Yes, Your Honor.
And have you explained to her right to have these cases submitted to the Richland County and Colleton County grand juries?
I have, Your Honor.
You believe she understands the charges, potential punishment, as well as her rights?
I do, Your Honor.
And have you discussed with her right to have the Richland County case heard in Richland County and the Colleton County cases heard in Colleton County?
Yes, Your Honor. We waive jurisdiction.
Okay, so I'm agree to have it heard here in Colleton County.
Yes, Your Honor.
All right, you Ms. Hill,
Yes, sir.
how old are you?
58,
How far did you go in school?
high school.
What do you do for a living?
Now I'm currently retired.
Married?
Yes, sir.
Do you have any children?
I have 2 children.
Do you suffer from any physical or mental condition that would prevent you from understanding what we're doing today?
No, Your
Have
Honor.
you consumed any alcohol, drugs, or other medication that would impair your ability to understand what we're doing today?
No, Your Honor.
You understand this plea is taking place here in Calhoun County, and you have the right to have both of or 3 of the charges heard in Colleton County and 1 heard in Richland County.
Yes, Your Honor.
And you agree to waive that, and you want me to hear it here today.
Yes, Your Honor.
When you enter a guilty plea, you give up important constitutional rights. Those include your right to remain silent, not be compelled to testify against yourself. You also have a right to a jury trial where the state would have to prove you guilty beyond a reasonable doubt. In the event you exercise your right to a trial, you have the right to have Mr. Lewis cross-examine and confront witnesses against you and compel witnesses to appear and testify on your behalf. You also have the right to have these 3 of the charges presented to the Colleton County grand jury, 1 of them presented to the Richland County grand jury, where in each of those cases, 12 of 18 grand jurors will determine whether or not the case goes forward. Finally, you have the right to present certain defenses which you waive or give up when you plead guilty. You understand all those rights?
Yes, Your Honor.
Understand the rights I've explained to you. Do you wish to plead guilty and give up those rights?
Yes, Your Honor.
And you're pleading guilty to 2 counts of misconduct in office, is that correct?
Yes, Your Honor.
And Mr. Hubbard's range is not on here.
It's 1 year and a fine of up to $1,000. I apologize, Your Honor.
Okay.
I did not put that on any of the Senate sheets.
And the obstruction of justice,
Carries up to 10 years.
up to 10, and perjury is 5.
Yes, sir.
Okay. And Ms. Hill, you understand the potential sentences in each of those cases?
Yes, Your Honor.
Now, do you fully understand the nature of the charges against you and the range of possible punishment?
Yes, Your Honor.
Are you satisfied with the manner in which Mr. Lewis has advised and represented you?
Yes, Your Honor.
Have you had the opportunity to review all the evidence against you and discuss it with Mr. Lewis?
Yes, Your Honor.
Do you need any more time to speak with him?
No, sir, I don't.
You believe he's done everything for you that he could or should have done?
Yes, Your
Are
Honor.
you completely satisfied with his services?
Yes.
Has anybody promised you anything or threatened you in any manner to get you to plead guilty here today?
No, Your Honor.
You understand you got 10 days from today's date to appeal your guilty plea and my sentence.
Yes, Your Honor.
Understanding the nature of the charges and the consequences of a guilty plea, how do you plead here today?
I plead guilty, Your
To
Honor.
all 4 charges?
Yes, sir.
Tell me about it, Ms. Coven.
Yes, sir. Thank you, Your Honor. And I'd like to begin, if I would, explaining why I'm here. This was an Attorney General's case. This is not a conflict case, but Attorney General Alan Wilson wanted to bring me in as a fresh set of eyes, let me build up my prosecution team, gave me the benefit of Ben Applin, one of his appellate lawyers. But I do have the letter where he designated me to handle this case with my team. It's dated July 10th of 2024. I'd like to make that a court's exhibit.
And I guess maybe we should explain as well why I'm here. I was appointed by the Chief Justice with exclusive jurisdiction over this case to hear it anywhere in the state because by Chief Justice Kittredge's order, so I guess that would explain that as well. So go ahead.
And thank you for having us here, Your Honor. I mean, for us, in talking with the defense, it wasn't important where we handled this, just as long as it was handled. But, Your Honor, the authority given to me specifically, both in the letter and vocally to me, was for me to lead my team and for me to make that decision whether there's anything to prosecute, and if there was, to proceed on it. I had carte blanche authority to proceed as I saw fit. So the team I have my deputy solicitor, Suzanne Mays, who's got 30+ years in, Bruce Norton from my office, an assistant solicitor, and again, I mentioned Ben Applin with the AG's office, and frankly, I'd love to have an appellate lawyer on every case I prosecute, so it's been great having him. And I got my staff, I've got Lauren Biggerstaff, who's my paralegal, and I've had 2 investigators on this case. I've got Jane Sully Sullivan and John Bishop from my office, so this was a collaborative effort. This is how we approach our cases. Our goal was to simply look through the massive investigations that were conducted here and to see what, if anything, rose to the level of a crime. And if something did, could we prosecute it successfully and prove it beyond a reasonable doubt? There's 2 separate investigations, generally speaking. There was SLED, but also the State Ethics Commission. Each independently had investigations into Ms. Hill's conduct. Those investigations overlapped to some extent. The ethics investigation began July of 2023. 2 separate complaints came in concerning Ms. Hill about potential misconduct during her tenure as clerk of court. These investigations by the Ethics Commission uncovered what they believed to be numerous instances of ethical violations, and our job was to review those findings and see what, if anything, rose to the level of a criminal offense. The SLED investigation began January 5th of 2024 into potential criminal misconduct, again, from Ms. Hill, involving both money matters, but also issues arising out of the trial of State versus Murdoch. What we did is we met with all of the SLED investigators and with the investigators from the State Ethics Commission. We reviewed all their reports, including their interviews, their audio interviews, their video interviews. Some instances we asked for additional information so we could have some clarity on issues. And our focus again was what appears to rise to the level of a crime, and can we prove it in a court of law beyond reasonable doubt? I'm a firm believer that if I can't prove something in court, I'm wasting my time bringing a charge. Our review resulted in 4 separate charges, the ones that are before you: 2 counts of misconduct in office, an obstruction of justice, and a perjury charge. Beginning with the first misconduct in office, which is indictment 289. That deals with money, and frankly, Title 4D money and some other county money out of Colleton County, and where Ms. Hill gave herself bonuses. As you know, Title 4D money is a program, a federal program, and it's created to help families get assistance with child support. It has an enforcement mechanism where a clerk of court can augment the salary of her employees for that enforcement process. And technically, it's supposed to be, you give them a percentage of money based on the percentage of work. The money she was providing was styled as a bonus. I didn't have an issue with that, but the issue we did have is that she gave herself this money as well. And Your Honor, we believe that as an elected official, you cannot augment your salary. It goes directly to the statute that she's indicted under and to the common law as well. You cannot monetarily benefit from your elected position. And so over a period of September 1st, 2021 through March 5th of 2024, she awarded herself a total of $9,880 in bonuses in Title 4D money. In addition, she awarded herself $2,000 in bonus money from her clerk fund, her Colleton County Clerk of Courts office funds. We believe all that was inappropriate because that augmented her salary. The total restitution for that is $11,880. And I'm talking to the defense, they do have a check prepared today to pay that amount back, and it's to Colleton County. Colleton County will then put it in the proper accounts. As to the other misconduct charge, June 7th of 2023, Ms. Hill used her official position as clerk of court to promote her book, Behind the Doors of Justice, The Murdaugh Murders. She filmed a video promoting her book in her office with her nameplate, clerk of court. She clearly used the trappings of her office in this video to promote her book. There was one purpose of the video: to sell books. The video was then published through the Walterboro Chamber of Commerce's official YouTube channel to put that information out there to advertise her book. Again, the theory behind this is the same as the first misconduct charge, that she was using her office to make money, and you can't do that. Both charges arose initially out of the State Ethics Commission's investigations. There was overlap with the SLED investigations. Turning to the SLED investigations, the primary one that we ended up focusing on was what we've now got as obstruction of justice, which is the 10-year misdemeanor charge under the common law. While serving as clerk of court during the trial of State v. Murdaugh, she provided unauthorized individuals with access to sealed exhibits in violation of a written order from the judge, Judge Newman, but also is in violation of her duties as clerk of court. Specifically, January the 14th of 2024, SLED was advised that there were several graphic crime scene photos that were designated as sealed exhibits during that trial, and they had been released improperly. SLED also received photos of text messages containing pictures of these sealed exhibits. The contents of the photos indicated they had been taken inside the Colleton County Courthouse. The investigation established that the photographs of the sealed exhibits were posted on Twitter after a member of the media shared the photos with personal acquaintance. The metadata of those photos, as Your Honor knows, in the digital age, you don't just have a photo, but we can tell where it was made, when it was made. The metadata from the pictures of the sealed exhibits showed the photographs were taken on February the 28th, 2023 at 7:49 p.m. inside the Colleton County Courthouse during the trial of State v. Murdaugh. In fact, it was after hours, so there was no business going on at the courthouse. The security card access log showed that Ms. Hill's security card was the one that allowed access to the secured area where the photographs were taken, and that access card showed she was there from 7:46 p.m. to 8:06 p.m. So it puts her there at the time these sealed exhibits were photographed. These same photographs were then placed on Twitter and shared with others. An interview with a member of the media who admitted being present at the time acknowledged that Ms. Hill provided multiple members of the media with unrestricted access to evidence from the Murdaugh trial, including those sealed exhibits. Obviously, These were photos that the jury was going to see or had, were presented in court, but the judge was obviously very concerned about the public seeing them and any type of influence that it might have on the jury. There's nothing in the investigation that shows that any juror members were affected by this. Obviously, it's a serious charge, violated a judge order, but also it threatened the integrity of the trial itself. The perjury charge arose much later. That's a 5-year felony. January 29th of 2024, Ms. Hill was called to testify in a hearing before former Chief Justice Jean Toll regarding allegations of improper jury contact during the Murdaugh trial. While being questioned under oath, there was an issue of some photos that were sealed that improperly got out into the public. It turned out that those had not been sealed. It was a mistake. But what Justice Toll did is she then questioned Ms. Hill specifically about those sealed exhibits. She asked, quote, "Did you ever allow anyone from the press to view the sealed exhibits?" And this is under oath, and Ms. Hill's response was no, ma'am. Later during the same line of questioning, Judge Toll asked, quote, "Were any press people ever allowed to view exhibits, even the sealed exhibits that you had on file?" And again, Ms. Hill's answer under oath was no, ma'am. That constitutes perjury, and that's the basis for that charge, Your Honor. These investigations covered a wide variety of actions, a number of them that we looked at, but we didn't believe we had enough evidence to proceed on, including allegations of wiretapping. The court may know that Ms. Hill's son, Jeffrey Hill, right now has pending charges for wiretapping. He served as the IT director for Colleton County at the same time she was clerk of court. So when they were investigating that complaint, SLED was also looking at Ms. Hill to see if she was part of that wiretapping. This was back in 2023, as I said. Ms. Hill, being subject to that investigation, there was never evidence that she had knowledge. That's something I would have to proceed forward. It appeared clear that she had information from her son that we know he gleaned from wiretapping. But we had no evidence to link her and show knowledge of wiretapping. And Your Honor knows that would be a fatal charge. There would be a directed verdict. If I did indict and try to proceed, I could not prove that. The other issue we looked at was improper jury contact, which was the basis of Justice Toll's hearing. Of course, our standard of review is very different from the one the court will take. For us, we were looking at, did action take place that arose to the level of a crime? And if there was action there, could we prove it beyond a reasonable doubt? It's the way we approach everything. That's what we do as prosecutors. Specifically, there were 3 jurors who alleged this improper contact. I'll just refer to them by numbers because right now, the only person I'm focused on, and the authority I have to focus on, is Ms. Hill. But juror number 630, who actually served on the jury and rendered a verdict on that case, was one of those. Juror 785, who was removed by Judge Newman during the course of the trial before deliberations. He removed her for the purpose of improperly discussing the case with others before the deliberation began. And the final juror that brought an allegation was juror 741, who served as an alternate and did not participate in the verdict. These 3 jurors, particularly 785 and 630, have given multiple and different accounts of Ms. Hill's conduct. All of them have their own variation of what they say happened, and all of them, at least in post-interview, specifically 785 and 630, have changed somewhat in what they have said. None of them brought these issues up before the court at the time. This information came out after defense attorneys for Mr. Murdaugh were looking and talking to jurors. Nothing improper on their part. They have a right to do that. Just at various issues they were looking at. These inconsistencies that we have, particularly we have affidavits, but like one affidavit from 630 says her vote, the pressure she felt was from other jurors. She makes allegations about Ms. Hill's conduct, but that her vote was basically the pressure she felt from other jurors. That has since changed. As Your Honor knows, if I were to prosecute this case, all three of these jurors would be my key witnesses. And the inconsistencies would be insurmountable if I proceeded forward. In addition, what SLED did is they interviewed the remaining 11 jurors. None of them corroborate these three jurors. One juror out of that whole bunch said something about, Ms. Hill said something about the defendant's demeanor, but in his statement to SLED, he said, I didn't know what she was talking about. My vote was my vote. It was based on the evidence. So there was nothing to really go on with that juror. Otherwise, all of them denied everything that was said in the back room by Ms. Hill. Many of them said she was very professional when she was back there, and she only talked about the things that the judge had sent her back there to talk about. I would be facing a trial with 11 witnesses on a jury coming in to say everything the state is saying is not true. In addition, Your Honor, when Justice Toll had her hearing in Columbia on jury misconduct or Ms. Hill's improper contact with the jurors, she also interviewed each of those 11 jurors under oath, and again, they all reiterated that they didn't hear anything and that it didn't affect their vote. The court has a different standard, obviously, and I know there's appellate issues in Murdoch. That's not my concern. My only and sole concern was what evidence do we have, and then can I prove it in a court of law beyond a reasonable doubt? And the answer is, frankly, I don't know that I have enough based on what we have to even get an indictment, but I do know this based on my 35 years experience and the collective experience of the team we have. We could not get a conviction because we cannot prove that case beyond a reasonable doubt. Your Honor, those were the major issues we looked at. As Ms. Hill pleads today, she has no record. Again, other than the misconduct charges being from common law to statute, there are no recommendations or negotiations as to the sentence.
All right, Ms. Hill, do you substantially agree with the facts that the solicitor just told me?
Yes, Your Honor.
I find there's a substantial factual basis for the decision to plead guilty. I find that her decision to plead guilty is freely, voluntarily, and knowingly made. Ms. Hill understands she's giving up important constitutional rights by pleading guilty, and she has had advice and counsel from a competent attorney with whom she says she's satisfied. Mr. Lewis.
Yes, Your Honor. I do want to address just a couple things regarding sentencing, and I know Your Honor's familiar with everything that's laid out by Solicitor Hubbard. First and foremost, Ms. Hill's coming here accepting responsibility from day one. I think Solicitor Hubbard and the Attorney General would agree in all of those investigations that were discussed from day one, Ms. Hill has cooperated. And in every courtroom that I've been in, cooperation results in a benefit for the defendant. But I would be remiss if I did not talk about what Ms. Hill is not pleading guilty to. Okay, and Solicitor Hubbard hit this a little bit, but frankly, for the benefit of a lot of people watching, for the last few years, the allegations about Ms. Hill, whether it be jury tampering or wiretapping, that's not why we're here. That is not for consideration for Your Honor. And that is not what she's accepting responsibility for. She's accepting responsibility for what she did. And it was serious crimes and serious misconduct, and that's why she's here. But when we get rid of the noise surrounding this, we actually look at the conduct in front of Your Honor. And Your Honor, I'm a product of federal court predominantly. That's kind of how I think about these sentencing issues. And I think about the three goals of sentencing. That when someone's sitting you and what you're doing, it's specific deterrence to prevent her from reoffending, general deterrence, someone else sees this, we don't want them to do it, and then full justice for the victims. And when I look at that framework for Ms. Hill, well, there is truly no one who can come in this courtroom and say that Ms. Hill, 58-year-old grandmother, a mother, has been employed her whole life, helps almost every single day with one of her special needs grandchildren, taught herself sign language to help people, including her goddaughter, served her community, and continues to do up to today, is at any risk of reoffending. And the fact that she has agreed from day one to accept this perjury count as a felony, she's literally logically prohibited from creating misconduct in office again, which she can't legally do. So the risk of reoffense, at least as to Ms. Hill, is non-existent, regardless of all respect, regardless of your sentence. If I think about general deterrence, I don't think anyone who's watched the saga that Ms. Hill's gone through over the last couple of years would think this is a good idea. I mean, a lot of times we think about collateral consequences in this circumstance. She's lost her life. She's given up her position. She faces shame every day. I mean, she's frankly on home detention right now in her own community, just trying to avoid the hoopla that's going on surrounding Ms. Hill. I don't think anyone in their right mind would think this is worth it. On top of that, Your Honor, for the last consideration, full justice to the victim, the only victim that has been named is Colleton County. And before she pled guilty, Ms. Hill has given a check for full restitution for every single dime that she has of any monetary benefit for any of these alleged schemes. She is paying back. And that is her trying to right the wrongs before her. So when we look at it from those circumstances, Your Honor, if we're thinking about, a punishment that is sufficient but not greater than necessary to achieve those goals, a non-custodial sentence is the only reasonable sentence. The last thing that I will touch on before Ms. Hill speaks to you is we always try to avoid sentencing disparities in these circumstances. Now, fortunately, in South Carolina, at least recently, we do have a history of Attorney General prosecutions of former public officials involving misconduct in office. And when I looked at prior sentences involving misconduct in office, involving significantly more money, taken over a longer period of time, with more repeated conduct than what we have here, just these limited bonuses, we have non-custodial sentences. I even ran the federal sentencing guidelines because I couldn't find a perjury prosecution sentence. Fully, Your Honor, I couldn't find one from state statistics. And I ran it under the guidelines, which I know from your prior experience you're familiar with. That's a base level 14, 3 levels down, she's 11. That's a split sentence, non-custodial, even in federal court. So if we're looking at similar sentences given for these type of crimes for someone with no criminal history like Ms. Hill, frankly, there isn't precedent, unless they know something otherwise, and I don't think they do, for a custodial sentence in this case, Your Honor, at least from a sentencing disparity. And the last thing I'll say before you hear from Ms. Hill, Your Honor, is she's going to give a short statement, and I've been on the other side of hearing these statements. I've observed a lot of sentencings. I've been here where you hear I'm sorry, and you hear I'm ashamed, and you hear I'm going to do better. And a lot of times, I think those statements fall on deaf ears because the person making them can't support it. It's just something said after I get called. That is not the circumstance that we have with Ms. Hill. We have support. She's trying to make things better. She literally is paying back every dollar she owes. Since day one she's been approached with this, she has cooperated. She has done what she's supposed to do. This does not minimize her crimes, but in the context of committing them and who she is as a person and what she's going to do, she's doing the right steps. So when you do hear this statement from Ms. Hill, I hope that you see the support behind it. And we do ask for any non-custodial sentence within your discretion, whether that be probation, home detention, anything else. But we do feel that a custodial sentence in this case would result in a sentencing disparity unwarranted by the circumstances, Your Honor.
All right.
Thank you, Your Honor.
Ms. Hill.
Your Honor, I want to say that I am truly sorry. And I do take full responsibility for my actions. And I know that I have let down this court, my community, and the people that put their trust in me. There is no excuse for my mistakes. I am ashamed of them. And I will carry that shame with me for the rest of my life. I have already begun the hard work of rebuilding the relationships that I damaged by accepting responsibility, by seeking forgiveness from those that I love, and by repaying any improper bonus I received. I am committed to making amends, to being honest, and to living in a way that reflect the values that I failed to uphold. Your Honor, I respectfully ask for the opportunity to continue supporting my family and to work every day to rebuild the trust that I have broken.
Thank you, Your Honor.
Okay. Anything else?
No, Your Honor, nothing. Thanks.
All right. Anything else, David?
No, sir, Your Honor.
Mrs. Lewis, did she have any time served?
No, Your Honor, she was there for about 8 hours.
So a day? All right, I've certainly, taken in what all has been presented here today, and I can tell you, Ms. Hill, had, Mr. Hubbard's team uncovered any sort of jury tampering, there would be a much different sentence here today. There's probably nothing more sacred in our system than the jury, and had there, and I have known Mr. Hubbard since his hair was dark and I had some hair. So if his team, and I know both the lawyers on his team, and if they tell me at least they couldn't prove it, then that's enough for me. I'm sure you have, and I know you've been humiliated throughout this whole ordeal, but of your own doing. I think a lot of folks got swept up in the hoopla that was that trial, and unfortunately, with the obstruction charge, a lot of folks probably made a lot of money, but you didn't, by virtue of that. But with that being said, I would agree with Mr. Lewis. I don't think this, the conduct here warrants an incarcerated sentence. So on the misconduct in office, on each of those, I find should be committed to Department of Corrections for a term of 1 year, provided upon service of 1 day time served, balance be suspended with probation for 3 years. There will also be 100 hours of community service associated with one of those. I didn't put it on all the sentencing sheets because I didn't want probation to misinterpret it and give her 400 hours. Okay. On the obstruction of justice, I find should be committed to Department of Corrections for a term of 5 years. Provided on service, 1 day time served, balance be suspended with probation for 3 years. And finally, on the perjury, I should be committed to Department of Corrections for a term of 5 years. Provided upon service, 1 day time served, balance be suspended with probation for 3 years. Good luck to you, ma'am.
Thank you, Your Honor.